to today's Know Your Rights presentation. My name is Daniel Sharp, Chief of the Los Angeles County Office of Immigrant Affairs. Our mission, website, and hotline where the public can reach an office representative from 8 a.m. to 4:30 p.m. Monday through Friday is available there on the screen. Before the Immigrant Defenders Law Center team gets into the essence of today's presentation on understanding your constitutional rights, family preparedness, and potential forms of immigration relief, I'll briefly be discussing protecting yourself from immigration legal services fraud and finding the right legal help. So at this time of heightened concern around increased immigration enforcement, a lot of people are understandably seeking advice about their immigration situations. Our Office of Immigrant Affairs is housed within the county's Department of Consumer and Business Affairs, which investigates all types of consumer fraud, including immigration legal services fraud. And we see on a regular basis the devastating consequences of those who turn to unauthorized immigration providers and often lose large sums of hard-earned money, and worse, suffer the immigration consequences, which in many cases cannot be fixed after the fact. So it's really important to understand who can provide you advice in representation in your immigration case. There are only two categories of persons who can provide that advice and representation. An attorney is the first category. An attorney licensed in any state or Washington, D.C. can practice federal immigration law in California. A non-California attorney practicing here must indicate the state that they are licensed on their advertisements, including their business card, so you can verify that they are in fact an attorney in good standing. The other category of authorized representative is what's called a federally accredited representative. These are individuals who work at nonprofit organizations that have gone through an extensive application process with the U.S. Department of Justice, where the organization must demonstrate that it has attorney supervision and can sustain an immigration law program. If the organization is approved, then non-attorneys working for the organization who have significant training and experience in immigration law can apply themselves to be what are called accredited representatives. And they can then give immigration advice and represent clients in matters before U.S. Citizenship and Immigration Services. And with enough training and experience, they can be approved to represent people in immigration court and before the Board of Immigration Appeals. But if they leave the nonprofit organization they're working with, they lose their accreditation. They cannot open up a private business and continue to represent individuals. And while they're at the nonprofit organization, they can only charge a nominal or small fee for their services. So it's really important now to understand who we should be avoiding. The many categories of individuals in the next slide, who we should avoid for all immigration matters. So this includes notaries public, immigration consultants, and tax preparers. In many Latin American countries, a notary is, in fact, a legal professional with substantial training. In the United States, to become a notary, there's a 1-hour exam, and most prep courses last about 3 to 4 hours. It is simply a witness to official signatures, not a legal professional authorized to give any advice in immigration matters. Immigration consultants, similarly, are persons who are regulated by the state of California who can only fill out immigration forms that their clients select as the clients instruct them. They cannot tell their clients how to answer questions on forms or which forms to use. So a person seeking advice in their immigration matters generally has questions that these individuals cannot answer, whether they're eligible for immigration benefits, how they should answer a question on a form, whether they should apply at all, or what their risks may be. Answering those most basic fundamental questions requires legal advice that only an attorney or an accredited representative can provide. If we move on to the next slide, I want to briefly mention that we have seen in recent years, sadly, an increase in online scams, including on social media, advertisements on WhatsApp and other social networks around supposed attorneys, often located in other states or outside of the country, promising help with new, often fake immigration programs. So it's very important to verify an attorney's law license. Ideally, you should be able to meet with an attorney in person. If hiring someone out of state, verify their office address and phone number and make sure you can contact them rather than responding to an online advertisement. And then, of course, never hire an intermediary who promises that they will connect you to an attorney. You should hire the attorney yourself, and never hire anyone, an attorney or non-attorney, who says that they have special connections with immigration officials, asks you to sign blank forms, tells you to lie on an immigration form, or refuses to provide you a contract. You can find more information on the Office of Immigrant Affairs Immigration Fraud landing page around filing a complaint with our department if you have experienced immigration fraud, and identifying authorized service providers, including a link to Immigration Law Help, which can help you identify authorized providers around the country and is searchable by zip code. So if you have additional questions, you can also reach our counselors Monday through Friday on the number on the screen. And with that, I will hand it over to the IMDEF team.
Hi, everybody. My name is Melissa Shepard. I'm a Director of Legal Services at Immigrant Defenders Law Center. As our partner Daniel mentioned, we are a nonprofit immigration pro bono provider for specifically removal defense, or also known as deportation defense. I have with me my colleague Valerie Aguilar Quintanilla, who's a program associate with our welcoming team, where we provide community education as well as pro se services. So she is going to walk us through some of the constitutional rights and general information about how to best protect yourself and your loved ones in your community. And then I will get into a little more immigration background, different forms of relief, and things to keep in mind as we continue to receive information and updates. So I will let Valerie go ahead and get started.
Thank you, Melissa. So as Melissa stated, regardless of immigration status, everyone in the United States has some form of basic constitutional rights. You can find these within the 4th, 5th, and 6th Amendment. And so listed on the left are your constitutional rights, especially important when you are interacting with immigration agents or immigration enforcement. And so the first is the right to remain silent. So that means that you do not have to answer any questions. So if an ICE agent approaches you and wishes to ask about your legal status or your country of origin, you can say that you are exercising your right to remain silent. Another is the right to not answer your door without a judicial warrant signed by a U.S. judge. And on the next slide, we'll go over the difference between an administrative warrant, which is typically what ICE carries, versus a judicial warrant, which is signed by a federal judge. The next right is the right to speak to an attorney. And so you have the right to not sign anything without an attorney being present. So if an ICE agent or immigration enforcement asks you to sign a document, you can say that you are refusing to sign until you speak with an attorney. So those are some of the basic constitutional rights that everyone, regardless of immigration status, has. And on the right, you can see that it is a red card. And so typically red cards have come in multiple languages. English and Spanish is the most common that we see, and you can purchase those from the Immigrant Resource Legal Center, or you can print them out for yourself and hand it to your community members. So I mentioned before, ICE does not have the authority to enter your home or your car without a judicial warrant, but they usually also carry an administrative warrant. So we're going to go over the difference between an ICE administrative warrant versus a judicial warrant. So the first one on the left is an ICE administrative warrant. At the very top, you can see that it is issued by the U.S. Department of Homeland Security. And at the very bottom, you can see that it would be signed, but it's going to be signed by an immigration officer versus being signed by a judicial judge. Therefore, this does not give ICE the authority to enter your home or your car. On the right, you see a judicial warrant. It clearly states at the very top that it is being issued by the United States District Court versus a department. And at the very bottom, you will also see that it is going to be signed by a U.S. judge. So if it is addressed to you and it has your correct address and location, and it is signed by a U.S. judge, it does give ICE the authority to enter your home and car. And we know that ICE will typically try and use use a variety of tactics to scare you into allowing them authority to enter your home or car with an administrative warrant. But it's really important to pin those key differences. And another important thing is that when you are asking to see a warrant, do not open your door or do not open your car to view the warrant. Ask them to put it up against the window, or if you have a door that doesn't have a window, through the peephole, or slide it under the door. Okay, so what can immigration enforcement look like? So they can look in very different. So as you can see, we have Customs and Border Patrol, Immigration and Customs Enforcement, and undercover agents. So typically they're going to wear street or casual clothing. As you can see, they're wearing blue jeans. They're going to have some sort of a protective gear. Typically, we've seen them in the bulletproof vest that says police, ICE, or federal agent at the back. And then you can also see their vehicles. They come in SUV or van models, have a blue or green stripe, and it usually has the U.S. Customs and Border Protection logo. We have also seen undercover agents and therefore also unmarked vehicles. The most common models can be Ford, GMC, Chevrolet, etc. And so we just recommend that you remain vigilant and just stay cautious. So what happens if a loved one is detained by ICE? So you would be able to use the ICE detainee locator to find their location. There are two ways that you can find a detained loved one's location. So you can use the A number, which is a 7 to 9 digit code administered by immigration. If you do not know their A number, you can also look up someone based on their name, country, and birth date, which is under biographical information. A key thing to also note is that when it comes to the biographical information, if someone has multiple last names or goes by a nickname or has a middle name and goes by it on their first name, we would also suggest that you try a variety of different names, as it may be entered into the system differently. Another thing to also note is that minors will not be listed or cannot be found using the detainee locator website. If they are under 18 and they were detained with their parents, you can use their parents' information to look for them. If it's an unaccompanied minor, we suggest that you call the Office of Refugee Resettlement. And another thing is, once you do locate a loved one and you locate their detention center, if you are undocumented, we advise that you should not visit a detention center. These are highly secured areas, and so for your safety, we suggest that you do not go and visit. So how to keep your family prepared in case you are detained. So we suggest that you keep important documents in a safe place and tell someone you trust where they can find them. So for example, it's on the top dresser, it's on the bookshelf, it's on the nightstand in the master bedroom, somewhere that everyone in the household and even your children will know where to locate. We also recommend that you keep important documents in one place. So that could be a folder that's written down with important documents or immigration documents, or even a box, something that's recognizable and everyone knows what it looks like within the household. So what are some documents you should keep in there? You should keep birth certificates, passports, financial documents, any immigration documents, or any proof of U.S. residency. For DACA, that could be work permits or a USCIS receipt. For visas, and then green cards for legal permanent residents, and then other forms of U.S. identification. Prepare a plan of action for children or elderly family members, so who will take care of them in the event that you cannot. Identify someone in the family or a loved one who would be able to do so. Write down any information that we need for their care. So that includes allergies, medications, access to those important documents we mentioned before. And again, make sure to communicate with your children about this plan. And we also recommend that you could communicate to your children about the rights that they have here in the US, especially their constitutional rights. It's important to have children and all family members aware of how to best prepare at this time. So in the topic of documents, here are some documents that we suggest that you carry with you. And so if you have some form of legal status, we would recommend that you carry an evidence of that. And so if you are a legal permanent resident, that would be your green card. If you have some kind of work authorization within the United States, like your EAD card pictured at the very bottom left, we recommend that you carry that. If you have your social security card, we recommend that you carry that, and then some kind of form of state or state ID. So in this case, in fact, California, it would be the real ID, or even the driver's license, even if you have an AB60 provisional driver's license. If you have a red card, also carry that red card to remember your constitutional rights. And then another thing is, if you are in the process or petitioning for an adjustment of status and you have received the USCIS receipt, we recommend that you also have a copy or take a photo of it and have that on your phone. If you're also in hearing proceedings or you're in immigration proceedings here in the United States, having a copy of that on your phone or having some evidence of that is also really important. Some documents that we suggest that you do not carry with you are some that may show that you are from a different country of origin. So that includes foreign passports, such as this one pictured of a Mexico passport, or different identifications, as you can see listed over here. And what is not pictured here, but is really important to note, is to not carry any false documents with you. This is considered a federal crime, and so please do not carry any fake documents with you or present it to an agent. So what to do if you encounter ICE in public or at your workplace? If you have some form of legal status, such as if you're a legal permanent resident, we recommend or we suggest that you carry and show your permanent resident card. So you have any legal status. If you do not have any legal status, we recommend that you exercise your right to remain silent. Please do not run away or flee the scene if you see ICE in public or at your workplace. As mentioned before, say as little as possible and declare that you are exercising your constitutional rights. Ask if you are being detained. If no, ask if you are free to leave. And if they say yes, please leave as calmly as possible. As I mentioned in the last slide, never present false documents. That is a crime. Do not sign any documents. You can exert your right or exercise your right by saying that you will not sign any documents without an attorney being present. Do not give any information about your country of origin. And once again, the big thing is you do not need to answer any questions that they pose to you. And so what to do if ICE is at your door or car? So ICE agents, again, must have a judicial warrant signed by a judge with your full name and address to enter your home. Ask the agent to show you any document through the window or under the door. Do not open your door. If you do not have a window next to your house or you can't access under the door, ask them to show it through the peephole. And then at your car, do not crack the window open. If they forcibly enter your home, do not resist and remain silent. Do not physically resist, and remember your constitutional rights. And then you have the right to speak to an attorney, even if you are detained. And then next, I will pass it off to Melissa to talk about most common types of entry.
Thank you, Valerie. All right, so there are many different types of manners in which people enter the United States. And so I wanted to quickly review some of the most commonly seen forms of entry. So the very first one that I wanted to talk about is called entering without inspection. Oftentimes we see folks who enter through the desert or through the mountains or perhaps crossing a river. They may enter undetected, or they may be apprehended by Customs and Border Protection, where they are then placed into the process where they might be given in notice to appear in immigration court, which we'll talk about in a little bit. Secondly, somebody may enter with a visa, some type of tourist visa or student visa, and either they have continued renewing that visa, or they may have converted it to another visa, or a lot of times we may have community members who entered with some type of visa, and once that status ended, they fell out of lawful status. Finally, another method that people frequently enter with is either through some type of parole. We list here specifically the CBP-1 appointment. That program has since ended, but there are a number of migrants who entered with the CBP-1 appointment, and that allows them a temporary permission to enter the U.S. It's not just for folks who entered with a CBP-1 appointment. It can also be others who entered through various parole programs. For example, one that was specifically aimed toward Cubans, Haitians, Nicaraguans, and Venezuelans. So if you do enter the United States, oftentimes as an asylum seeker, if you enter without inspection or you present yourself at the border, you may be given that notice to appear in immigration court, but in addition have an obligation to have ICE check-ins. So oftentimes someone enters the United States. Once they get to their final destination, they have 60 days to get in contact with their local ICE office to set an appointment. This is pretty typical for somebody who enters the United States and is in those removal or deportation proceedings, where they'll have to have regular check-ins with the ICE office, where the ICE office or the deportation officer will see what's going on in their case, ensure that they're complying with the various rules that they've been given. And so if you do have ICE check-ins, we highly recommend attending with an immigration attorney or an accredited representative, DOJ accredited representative to accompany you. So that way, if there are any questions as to what the current state of your status is, that representative may be able to help better explain it. You want to bring things like your identification, as well as your notification to appear in immigration court or any hearing notice, so that the deportation officer can see that you are attending your court hearings regularly. If you attend with a friend or a family member, please make sure that they have lawful status. You don't want to appear at one of these appointments with someone who does not have lawful status, as they will be at risk of being detained by the ICE office. So please keep that in mind, and make sure you attend those ICE check-in appointments if you have them. The next thing that we wanted to review is something that has kind of recently been rethrust into the spotlight. It's called expedited removal. So expedited removal is essentially someone who is subject to being deported. They may not have lawful status, and they are put into these expedited deportation proceedings where they're not given the opportunity to see a judge to seek for relief. So the change in that has been that in the past, it has only been used against persons who were within 100 miles of the US border. That can be land or sea entry points. And now it has expanded. So any person who is undocumented, even on the interior of the United States, could be subject to expedited removal. There are a handful of exceptions. And in particular, the most commonly seen one is somebody who may have been here for more than 2 years, can be exempted from the expedited removal process. So if that is your situation, or somebody that you know situation where they don't have lawful status, they are detained, but they have been here for more than 2 years, that person is going to want to prepare documents to show that they have been in the United States for more than 2 years. A couple other exceptions are unaccompanied children. Remember, this is a legal designation, so it's not just a child who may be here alone or without their parent, but upon entering the US, they are legally designated to be an unaccompanied minor. Somebody who was paroled in, for example, with one of the various parole programs, including the CBP-1 appointments, those folks are not subject to expedited removal. Anybody who was previously in an expedited removal process and may have passed their credible fear interview and are now in the United States, they are not subject to expedited removal. And folks who are already in immigration court proceedings, they will not be subject to the expedited removal process. So generally, we recommend that if you have been here for more than 2 years and you don't have lawful status, in the event that you are detained by immigration officials, you can show evidence that you have been here for longer than 2 years. And like Valerie mentioned, that can be part of your family preparedness packet where you have that evidence ready to go. So either your family or an attorney or some type of legal services organization is able to help argue your case so that you're not subject to expedited removal. I've mentioned the notice to appear a few times. The notice to appear is essentially the charging document that you receive when you are placed into removal proceedings or deportation proceedings. It will have your name, the A number, which Valerie mentioned. The A number is a number that's assigned to you and will follow you throughout your whole immigration case. So it's extremely important that you keep a photo of this document and know what your A number is, so that in the event that you are detained, your family can quickly access that number to help locate you. So this document also has the allegations that the government is saying, essentially of why you are deportable. So you want to make sure that the information on here is accurate. If any of it is inaccurate when you appear before the immigration judge, you will have the opportunity to correct or let the judge know what you believe is incorrect. The original notice to appear also does have information about your first court appearance. So it'll have a date and a time and the court. So ensure that you appear for your first hearing. Okay, so let's say you make it to your first hearing, you show up. It is possible and highly likely that you are going to have court several times before you have a resolution to your case. So at the first hearing, generally, you'll appear with an attorney. If you don't have an attorney, you can ask the immigration judge for additional time to find that attorney. Depending on the judge's preferences, they may give you a shorter or longer amount of time to find a legal representative who's able to help you. This is also when you will present your type of relief. And what I mean by that is kind of your defense to why you should not be deported. A couple other just logistics for court. If you do not speak English, you have the right to an interpreter. So, oftentimes we may see that in the form of somebody who speaks an indigenous language, but may also speak Spanish, for example. We encourage them to ask for an interpreter who speaks their best language, rather than proceeding with a hearing and possibly misunderstanding or just not understanding part of the process correctly. So on the notice to appear, I did mention that it has your address as well as the court address where you have been directed to go. If you move from your original intended address, you must update your address with both the court as well as with ICE. So for example, if you intended to live in the San Francisco area, for example, and you now intend to reside in the Los Angeles area, you need to affirmatively go online to the links here provided and update your address with ICE as well as the immigration court. With the immigration court, you will also need to request a change of venue. So what that means is, rather than having your immigration court as scheduled in San Francisco, since you're now living in Los Angeles, you want to ask the San Francisco court essentially to give up jurisdiction of your case so that a Los Angeles immigration court judge may be able to hear your case. So oftentimes we hear of folks who will make every effort to attend their hearing when it's in a completely different state. We highly recommend changing your address so that your court location can be changed, so you don't need to make that cross-country or out-of-state trip to the different immigration court. You should be able to update your address to the local court. Okay. So I want to briefly discuss different forms of relief. I will go into some of the most commonly seen ones, but for example, VAWATS, the Violence Against Women's Act, that does not apply to women only. It applies to both women and men who have been subject to extreme cruelty by their U.S. citizen or lawful permanent resident spouse. There may be a way to legalize your status through that process. You may also be able to get on the path to eventually getting legal status through a U visa. So that's for victims of crime, where a T visa is for trafficking victims. Generally, SIGIS is special immigrant juvenile status. So that is for a minor who was abused, abandoned, or neglected and are now here in the United States. You can also potentially find relief through deferred action or through various parole in place programs. But I wanted to walk us through a couple of the most commonly seen forms of relief. So the first is the U visa. The U visa is referred for victims of certain crimes. It's not for all crimes, but it is for certain crimes. For people who have suffered, were the victims of those crimes, but also who provided law enforcement with assistance. And that means filing a police report. That means cooperating with law enforcement to provide as many details as you can about that person. So, for example, if you are robbed, you want to ensure that you call the police immediately, file a report, let them know what happened. If you knew the perpetrator, you'll want to share that information. If you did not, provide as much information as you can. So as long as you have continued to provide law enforcement with information and in the investigation and prosecution of that criminal activity, it's possible that law enforcement agency can sign what's called a U visa certification, certifying that you were, in fact, the victim of that crime, but also helpful in the investigation. So adjustment of status, that is when you essentially apply for your green card when you are in the United States. So the benefit to that is for folks who cannot return to their home country for one reason or another. They don't need to actually leave the United States. The caveat here is it doesn't apply for everyone, right? You have to have some underlying basis for applying for that adjustment of status. So if you, for example, are married to a U.S. citizen or a permanent resident, we highly recommend speaking with an immigration attorney so that you can determine whether adjustment of status is appropriate in your situation. We also wanted to make a point of discussing DACA, so Deferred Action for Childhood Arrivals. That has been something that has greatly benefited our community, and I know that there have been a lot of concerns and rumors surrounding DACA, but as of today, there have been no substantive changes to DACA. That can always be changed in the future, but we really appreciate that this program gives opportunities for individuals who were brought to the United States as children and only know the United States as their home. So for folks who have DACA, we highly recommend keeping proof of your status in the United States with you, whether that means a copy or a copy on your phone. It's really important that you have proof of that status in the event that you are stopped or detained by an immigration official. You can show them your receipt notice or your approval notice, demonstrating that you are a DACA recipient. So as I mentioned, at this time, there are no substantive changes to DACA. However, make sure that you keep apprised of what's happening with DACA through reliable sources. Probably our most commonly seen form of relief in the United States and with folks who are entering the United States is through asylum. So asylum is a form of, it's when you are unable to stay safely in your own country, and because you have been persecuted in the past, or you have a belief that you will be persecuted in the future. Asylum can be based on one of the following reasons, as you'll see on your screen. It's race, nationality, religion, political opinion, or particular social group. And those have legal definitions as to what each one of those means, which is why consulting with an immigration attorney or legal services organization is absolutely vital, so you know which basis is the best method to pursue asylum for yourself. A couple notes about asylum is that you must file your application within 1 year of entering the United States. So, for example, if you enter January 15th, you need to file your application before January 15th of the following year, so by January 14th of the next year. That holds true even if your first court hearing date is not for, say, 15 months out from when you first enter the United States. You still have that obligation to turn in that asylum application within 1 year, or you risk being barred of qualifying for that type of relief. So please also keep in mind that there are no application fees when you are filling out the asylum application and turning it into the immigration court. A little more in detail about asylum, just because we understand that this is such a frequent form of relief that people are seeking. We like to think of it as, your asylum is in your hands, literally in your hands. So we want you to think, what happened to you? What is it that happened to you in your home country? Or what do you think would happen? So, for example, we may see a child who's being recruited into some type of criminal organization. They can say, this group was trying to recruit me and threatened me. So who harmed you? What group do they belong to? How do they know them? So it could be that criminal organization that's trying to recruit you into their organization. You're going to want to share details about any names, who they are, what group they're part of, what they look like, what they dressed like. You're also, the third prong for asylum is you're going to want to describe why. Why did that group threaten or harm you specifically? Why did they ask you but not your friends? Or why ask you or not your other sibling? What is it about you in particular that made them want to recruit you into their organization? You're also going to want to talk about the police. Did you file a police report? Why? Why not? If you did file a police report, what did the police say? Was there any type of follow-up? If you did not file a police report, why not? Is it because you've had prior negative experiences? So you're going to want to explain why you're not able to be protected in your home country. And then finally, your fifth finger here is there another safe location in your country? So, for example, if you're from Brazil is a really large country. One important aspect to your asylum case that you're going to want to explain to the judge is why you're not able to move to the northern part if you're from the southern part. And be able to adequately explain why in particular it's not feasible for you, or if you did try moving there, why it was not safe for you to remain there. Okay, so we wanted to also give you a little bit of an update of things that we have seen in just the last few weeks with the new administration and how it can impact us as well as our communities.
Melissa. So as Melissa mentioned earlier in today's presentation, CBP1 appointments, or the CBP1 entry has changed since the first date of the Trump administration. So since Monday, January 20th, the U.S. Customs and Border Protection announced that CBP-1 would no longer be operational. And so anyone who had pending appointments from January and February and so forth were automatically canceled. And so as of currently right now, if you entered with CBP-1 and are currently in the United States, we're not seeing any effect in regards to immigration court proceedings or if you're applying for a work permit or your social security card. And so currently right now, we're under the belief that the CBP-1 appointment decision from the Trump administration is affecting those who have yet to enter the country. However, with CBP-1 parole status and other parole status, there is the idea or the belief that those parole statuses will no longer be able to be renewed. So if you have an EAD and not being able to renew that EAD, with that, we recommend that you consult with an immigration attorney to see what other options are available for you. Another thing is ICE access and entry into protected areas. And so the Trump administration rescinded a Biden era memo that essentially listed areas that were considered protected from immigration enforcement. So a couple of those examples can be schools, it can be healthcare centers, churches, etc., or any services such as shelters, food pantries, domestic violence shelters, etc. Just to keep in mind that there are certain states such as California have enacted laws and policies that limit local and state police from interacting with ICE, especially in those protected areas. But however, regardless of if you were in a formerly protected area or in public, your constitutional rights within the United States remain. And so if you are in those areas that were formerly protected, we recommend that you practice those constitutional rights that we mentioned earlier in today's presentation, such as the right to remain silent. If you do work in these protected areas, think about privacy laws and privacy policies that you can enact in the areas that you serve or in the facilities that you serve. So for example, with ICE can access public areas, but they need a judicial warrant for those private areas. And so thinking about if there's like a public waiting room, how to make that private, etc. So those are some recommendations and suggestions we have in light of recent news.
We've also seen the Lake and Riley Act implemented, and that essentially says that there is mandatory immigration detention for anyone who has been charged with, arrested for, convicted of, or admit to one of a certain list of crimes. So that could be theft, burglary, assaulting a law enforcement officer, or any crime causing death or serious bodily injury. Now, this in particular is very concerning, very alarming for us, because it means that if somebody is merely accused of a theft crime, they can be mandatorily detained. We obviously see this as a huge issue of somebody's due process rights. And so please be aware that with the Lake and Riley Act, you especially want to make sure that you are staying safe out of any type of criminal trouble, because even an accusation of one of those crimes could mean that you are mandatorily detained. TPS is temporary protected status. We have seen that come under fire lately. In particular, we saw that this administration has decided to not renew the TPS designation for Venezuela. Reversing back our TPS for many countries, for example, El Salvador, where we've had that TPS designation for decades, would be catastrophic. We have a lot of people in this country who have rebuilt their lives, who are unable to return to their home countries due to various instabilities. So keep your eye out for any updates with TPS, but as of this moment, Venezuela is not going to be renewed.
So, important things to keep in mind. Always follow the laws of the United States. The age of consent in the United States is 18 years old. You can get a California's driver license or ID card at the DMV. This also includes AB 60. So, if you do not have any legal status, we suggest that you get an AB 60 provisional driver's license. That also is a form of state identification. And so, as we mentioned earlier, with documents that we suggested that you carry, we suggest that you also carry a driver's license. You also should be driving with a driver's license. And so that is an opportunity that Californians have. You should file your taxes every year. And make sure to enroll your children into school. And marijuana is not legal at the federal level. So we know that it is legal here in the state of California, but it's not legal in other states and especially at the federal level. And then here are some direct hotlines. Please take a moment to take a photo of them. But on the very left, we have the National Domestic Violence Hotline, Suicide Prevention Hotline, Human Trafficking, Sexual Assault, and Runaway. And so that was on the left. On the right, we have rapid response hotlines. These are mostly focused in Southern California, but essentially these are where you can report ICE activity. And when you are reporting ICE activity, it is important to consider the who, what, when, and where so that you can help the community members who are operating those rapid response hotlines to be as consistent and as descriptive as possible. So if you are reporting ICE activity, please consider what the activity is being done. Are ICE agents outside a door? Are they walking around in public? Are they doing a checkpoint and they're stopping cars? What do they look like? Do they have those SUV vehicles that have the blue and green stripe and the logo, or are they unmarked vehicles? How are they dressed? Are they dressed super casually as undercover agents, etc.? Note the date and time that the event has occurred. So if I'm reporting an ICE activity right now, I would note that it is happening on February 7th at 2:58 p.m. You would also be as specific as possible with the location, and this would definitely benefit the rapid response hotlines that you are contacting. Another thing is that IMDEF has its own rapid response hotline. Just to note that the other hotlines are to report ICE activity, but this hotline specifically is only for legal resources. So please do not use it to report ICE activity. But essentially, IMDEF's rapid response hotline is for Southern California community members who are detained by immigration enforcement. So if you know someone or a loved one or a community member of yours has been detained by ICE, please feel free to call our hotline. We are available from Mondays to Friday from 9 a.m. to 4 p.m. And we can help assist in some sort of legal resources in regards to that. And that is all the time we have. Thank you.
Thank you so much. That was really informative, and I'm so glad we're able to provide these resources for people who need this information. So I'm very sorry we're running short on time today, so we're not able to answer questions. For people who have questions, please refer to this presentation for the information and resources provided. You can reach out to many of the phone numbers here for the information that is specific to what you're looking for. And just as a reminder, the Los Angeles Public Library provides free and reliable affirmative immigration services. You can schedule an appointment by going to www.lapl.org/New Americans or by calling 213-228-7390. And as a reminder, this presentation is being recorded and will be available to play back on the LA Public Library YouTube channel. If you would like the presentation slides and resources, please email us at lifelonglearning@lapl.org. Thank you all for joining us this afternoon. Coming up in just a few minutes, we are conducting the same presentation in Spanish. Have a great weekend. Thank you.